What's up, everybody? It's Walter, your favorite historian and professor. Today's date is May 15th, 2026. So recently I was looking at a video of Supreme Court Justice Amy Coney Barrett expressing frustration at being labeled a conservative. And she, like many, does not like being placed into a box, which is certainly understandable. Justice Barrett prefers to be known as a constitutional originalist. Now, a constitutional originalist, in this type of parlance, is an individual who interprets the U.S. Constitution and other federal laws according to what they meant at the time they were adopted. Now, originalism has two distinct fields of thought. First, there are original intent theorists and original meaning theorists. To those who believe in original intent, you try to discern what the lawmakers who wrote those constitutional provisions or other federal laws, you are trying to discern what they intended to convey in writing those provisions or laws. Original meaning simply means you are trying to discern what and how those laws would have been interpreted by the average individual of that time period. Not necessarily judges, lawyers, or academics, but butchers, bakers, and candlestick makers. Okay? While they certainly have different followings, all in all, they reach the same goal as to what it would have meant at the time it came into effect. Okay? Whether it be the intent of the lawmakers who wrote it, or by the average individual of the day. Which leads me to the point of this whole video. In describing herself as an originalist, it's kind of strange how Justice Barrett could have voted with the majority then in Louisiana versus Calais. If she believes in originalism, then how could she believe in such a restrained reading of the Voting Rights Act of 1965? I wonder the same thing. The Voting Rights Act, passed by the United States Congress in 1965, was intended to be a broad, robust federal law designed to combat any and all forms of racial discrimination in voting and voting practices. That included not only the ability to cast ballots, but also vote delusion and legislative actions which not only had a discriminatory intent, but a discriminatory effect as well. Okay? The Voting Rights Act was not meant to be interpreted in such a narrow format. However, conservative legal scholars would argue the opposite. They would argue that the Voting Rights Act was intended to be a very limited federal law that was designed to target only the most extreme circumstances of intentional racial discrimination. And anything further than that would essentially trample on the sovereign power of the states to regulate their voting procedures and protocols as they saw fit. I do not buy that argument for 1 second. The Voting Rights Act, just like any other federal law, gives Congress the power to enforce it. Congress never gives itself limited power to enforce any federal law. Okay? Federal law of and in itself tends to have very broad, full encompassing power. And the Voting Rights Act of 1965 is no exception to that general principle. But conservatives have long been on the path to destroy that law, and Louisiana versus Calais is just the final nail in the coffin for all intents and purposes. I'll also add that no judge or Supreme Court justice is entirely consistent in an interpretive philosophy, whether they label themselves as an originalist, a textualist, or a living constitution theorist. All of them break ranks with those methods depending on what the issue is. Even the liberals are guilty of it, especially in the case of McDonald versus City of Chicago in 2010, as well as D.C. versus Heller in 2008. The living Constitution theorists, who tend to be liberals, took a very originalist interpretation of the Second Amendment in that case, giving it a very narrow interpretation, not interpreting that provision to include a personal right to keep and bear arms. Whereas, on the other side, the conservative originalists and textualists interpreted the Second Amendment in a modern day light and format, okay? Completely repurposing that amendment from James Madison's intent when he wrote it, all right, and it was subsequently passed by Congress. They interpreted the Second Amendment, which had an exclusively militia focus, to include a personal right to keep and bear arms that was free from infringement, not only by the federal government, but also by the state and local governments as well. So when we hear Supreme Court justices shun the liberal and conservative boxes and prefer to isolate themselves as originalists or textualists or believers in a living constitution, take it with a grain of salt, because they're not consistent in any of those things, and it all depends on the issue. Whatever issue they feel most passionate about, they can easily jump ship and join the other side, okay? And just because one is an originalist, as Justice Barrett purports to be, does not necessarily mean they're going to be conservative. If she were being truly intellectually honest, to be an originalist with the Voting Rights Act, she would have understood that the Voting Rights Act of 1965, as originally designed by Congress in that year, was not designed to be such a restrained law. She would have interpreted how the Congress of 1965 would have intended it, and that was to be a broad, encompassing law, which would have led her to side, okay, on the opposite position, joining Kagan, Jackson, and Sotomayor in dissent, not viewing the Voting Rights Act in such a constrained format as the majority did, essentially rendering it to be almost dead letter. Okay, so I just wanted to share that with you all, and you know, whenever you may hear Supreme Court justices box themselves into particular constitutional interpretive modes. But I'd love to hear your thoughts on the matter, so leave them in the comments down below, and we can talk about it all day and all night. But for now, it's time to go. Professor Shelton, the Blue Collar Scholar, out. Peace.